Welcome, everyone. My name is Howard Gould, and I'm co-chair of the real estate section for the Beverly Hills Bar Association. And we're very happy to have you back for what is an annual program we do, updating on the updates of the C.A.R. forms and other real estate related matters. And delighted to have Jana Gardner with us again this year. Before we begin, there's a few comments. Members of the real estate section are welcome to join our monthly executive committee meetings. We have one on March 24th next week. We usually do them either Tuesday or Thursday afternoons about 3 o'clock, and they're all on Zoom, so it's easy to attend. And we are doing our planning for upcoming programs and sometimes batting around some current real estate issues. We're looking for people who might want to take on a leadership role at some point, so you might consider that. I also want to remind you for this program, your questions should go in the Q&A, not in the chat, and we'll be following the Q&A. You can find in the chat a link to the program materials and other information about what's going on at the Beverly Hills Bar Association. BHBA is very good about getting you your attendance certificates after the program, and they're also available on the BHBA Plus site if you want to get them later. In terms of our upcoming programs, we have actually two next month. On April 16th, Howard Fisher and Levon Lawson are going to talk about 1031 exchanges. So you'll have some tax expertise on what's going on with 1031 exchanges. April 23rd is our annual review of the prior year's case law with Larry Jacobson presenting for us. May 21st, we have a program we've never done before. It's landlord insurance coverage for habitability claims in landlord-tenant disputes. Steve Raucher, who's a specialist on insurance matters, former president of this bar association, is going to lecture about the law and his experiences and what you find in the policies to get coverage for habitability claims on behalf of landlords. June 25th, we're also doing something we haven't done before. But our speaker is Brian Mashian. Brian spoke for us the last couple of years. He does a lot of presentations for American Industrial Realtors Association. The last couple of years, he talked about their purchase agreement and their lease form. This time, he's going to do something different. The topic is how to effectively represent a small tenant in negotiating a commercial lease. So it'll be more practical information about what to do when you have a client who arguably doesn't have a lot of leverage in a commercial lease negotiation. July is open for the moment. And August 20th, we're looking at doing a program on the newly revised CCP section 664.6 on settlement. Scott Ron, who is a trust, probate, and estate lawyer, a litigator. He and a couple of people from his firm did an article that appeared recently on the revised section 664.6 and what they called the death of finality. And there's a number of changes in this provision by which you can enforce settlement agreements and apparently special considerations for probate and family law practitioners. Scott's going to handle the probate side of that, and Al Provinciano, who's going to be president of this bar association shortly, is going to present the family law side of things. So my pleasure again to introduce Jana Gardner. Jana is senior counsel with the California Association of Realtors. Since joining C.A.R. in 2014, she is primarily focused on advising members through the legal hotline, as well as presenting legal update outreaches and teaching classes on disclosures and the residential purchase agreement. In addition, Jana prepares legal resources such as the legal Q&As for C.A.R., their quick guides, and co-hosts C.A.R.'s Legal Matters podcast. And she also presents the monthly Legal Tools Talk on C.A.R.'s Facebook page. Prior to joining C.A.R., Jana practiced commercial real estate law with Cox, Castle, and Nicholson, focusing on acquisition, financing, and leasing of commercial properties. Jana worked with clients ranging from national banks and insurance companies to small private lenders on real property secured financing transactions, including acquisitions, refinancing, loan assumptions, and modifications. Jana received her bachelor's degree in social science from San Diego State University and her JD from USC. And as I mentioned, she's a repeat speaker for us. And welcome back, Jana. All yours.
Thank you so much. Very happy to be back. Let me get my screen on here for us. All right, looking good?
Very good.
Excellent. Well, thank you again. It's very wonderful to be back with you all. I'm happy to have the opportunity to come back, usually this time of year, give you an update on what's been happening at the California Association of REALTORS over the past 12 months or so. As usual, it's been a busy few months with the new laws and going into effect on January 1st, and a lot of corresponding changes to our forms, as well as a few other changes that have transpired late last year since I was here about 12 months ago. So we have quite a bit I want to cover today. First, talking about agency and sales transaction issues. I always like to start with our RPA, since that's kind of the backbone of everything, what's new in our residential purchase agreement. One of the newest aspects to it is the federal reporting requirement purchase addendum. New FinCEN reporting requirements just went into effect at the beginning of this month on March 1st. So I'm going to talk about how we're handling that. Another important new issue locally, new law relating to prohibitions on unsolicited offers in fire-affected areas. And then I want to talk about agency updates, listing agreements, buyer representation agreements, constantly evolving area, and let you know what the current status of all that is. And then before we wrap up, I want to give a brief leasing and property management update. As there is every year, there are some pretty significant new laws that residential landlords of all sizes need to be aware of and stay on top of. And so, of course, we have updates to our forms to help landlords comply with those ever increasing requirements. So, like I said, I'm going to start off with the purchase agreement and start off with the ongoing hottest topic in it, which is how buyers agents compensation is handled and negotiated. So this is something that's, if you've been following along or even just have come to this presentation over the past 2 to 3 years, you'll have seen a change every time I've been here. There's been a lot of evolution in how this has been addressed in the contract. And so just to give everyone a very brief recap, if you haven't been paying close attention, it was back in 2024 when the N.A.R. settlement occurred, settling some lawsuits relating to buyer's agents representation. And then after the N.A.R. settlement occurred, we updated our forms. There have been some new California laws I'm going to talk about corresponding with it. And since that time, we've been wanting to make sure putting realtors in the best position as possible to be in compliance with all of these requirements while making sure that transactions can close successfully. And so that brings us to the current language we have in our purchase agreement about buyer's agents compensation. What we're looking at here is paragraph 3G3 of the residential purchase agreement, where buyers can request sellers to make certain concessions or pay certain compensation. Broken it down sort of into three sections. 3G1 is where a buyer can ask a seller to just give a general credit, typically applied to closing costs. That's the default. So for a buyer who they're putting every last cent they have into their down payment, they want the seller to contribute to closing costs. We have that section there. There's a place for them to sort of, maybe if they're asking for that, provide an explanation of what it is or why they're looking for. We've been hearing that it's becoming increasingly common for buyers to ask sellers to pay for interest rate buy downs, to pay for insurance premiums or HOA costs or things like that that might be especially financially burdensome, so they can indicate that. And then finally, separately, 3G3 is where the buyer can ask the seller to pay the compensation that's going to go to the buyer's agent. And I've had some questions about, why is this broken out separately? Why can't the buyer just ask, bottom line, here's the credit, let me apply it as necessary? And the answer to that, as the answer to most things is because of lending regulations. Lenders have very strict requirements about what credits a buyer can get. And in order to satisfy lender underwriting requirements, they want to see a separate breakout for, okay, this is a credit for a buyer versus buyer's agent, which is not going to hit that buyer credit limit. So that's why it's broken out separately. Ask the seller to pay whatever amount, could be a percentage, could be a dollar amount, for the buyer's agent's compensation. Now, the big change since I was here last is that there used to be an obligation of buyer's agents to provide, or buyers, I should say, to provide their buyer agent representation agreement together with the offer to substantiate the dollar amount. Or at one point, there was an attestation about the dollar amount that was called for in the buyer representation agreement. And after a lot of sort of feedback and analysis of how that was impacting transactions and brokers' practice, that went away. And so now it's just a bottom line, yes or no, seller, are you willing to pay this amount? Now, that doesn't change the existing rule that exists that comes from the NAR settlement that says buyer's agents cannot earn from any source an amount that exceeds what was agreed to in their buyer representation agreement that they were supposed to have entered into when they started working with the buyer prior to even showing them a property. So they have negotiated in advance. Here's the amount that I'm going to earn. And they cannot now go into the contract and ask the seller to pay some higher amount. They could ask for less, but they can't ask for more. And so we do have in our broker's compensation section, further down in the contract in paragraph 18, you'll see there is basically a reminder there, an advisory, just so that everyone remembers that that is the rule, that buyers brokers can't receive an amount greater than called for in the buyer representation agreement. I do find this is just a little bit more anecdotal, practice focused. I think a lot of escrows may still be asking to see buyer representation agreements. I get the sense that that's a little bit sort of regional, might be more common in certain areas or with certain companies than others. But I do get that question of, well, it doesn't have to be submitted with a purchase offer. What if escrow asks for it? And well, if escrow asks for it, then typically you're going to provide what escrow asks for. So it still may be produced in that context. Otherwise, that's what we're looking at with how buyers and sellers can negotiate for payment of buyer's agents' compensation. And when we get to the agency agreements in just a couple of minutes, I'll mention a couple other relevant points there.
I note that this says the commissions will be based on the final purchase price.
Yes.
Just to be clear that when things get changed at or near the end of the escrow period, the commission is going to get reduced if the price is going down.
Yes, yeah, exactly. So if there's been a percentage that's been agreed to, if the purchase price is reduced for whatever reason prior to closing, then that percentage is going to be based on that final closing price. That is correct. All right, just a couple other things to note in the purchase agreement that I want to highlight. Once again, like most years, we do have new mandatory disclosures for the sale of residential 1 to 4 unit properties. And there are a couple of them relating specifically to electrical systems and electrification. That's a really hot topic now and has been for a few years. A lot of air quality management districts and other types of local entities want to institute electrification requirements saying, okay, you have gas appliances, well, no more. If your gas appliances break, only new installations can be electric. And that could be significantly burdensome to someone who buys an old house with an old electrical system. They could find themselves facing a great deal of expense if they end up having to comply with electrification requirements. So new law says that for residential 1 to 4 unit properties, buyers need to be advised that they should get an electrical inspection because this is something they should be considering. So because it has to be disclosed on every residential 1 to 4 unit transaction, unless TDS exempt, but the vast majority of them, it's built right into our contract. Paragraph 11E of our purchase agreement, right in there. Here's the advisory. Buyer, you should consider getting an electrical inspection because you might be facing lots of expenses if you have to upgrade your electrical system to comply with future electrification rules. And just a note that a second part of this law is that if sellers have actual knowledge of a pending electrification requirement in their area, they know that there is a rule or there is one that could be coming down sometime soon, then our seller property questionnaire has a place to ask seller, are you aware of any existing or pending requirements? And if seller has actual knowledge, they need to let the buyer know that so they can take that into consideration as well.
A side note on this regarding our recent fires and the Palisades and the Eaton fire zone is that if you had gas previously, you may be exempted from some of the new requirements on electrifying everything and still be allowed to have some gas units at your property when you do a rebuild.
Oh, that's good to hear. I'm
How
glad.
long that'll stay in effect, I can't tell you, but right now, my understanding, and I am involved in this personally, is that you can put gas in your property if you're doing a rebuild.
Okay, very good to know. All right. And then one more purchase agreement paragraph I want to discuss before we start talking about the FinCEN rule and our addendum is an update to our assignment paragraph. So we've had this assignment paragraph dating back, well, we've always had a shorter version of it. It's been expanded for about 5 years or so now because there's been an increase in the prevalence of assignments. We hear a lot of reporting from agents out in the field of what they refer to as wholesaling, which is essentially people getting into contract, tying up a property, and then trying to go flip the contract for a profit during escrow. And so we have an assignment paragraph that lays out when and how assignments can take place during an escrow period. What has been added is a little bit more of an explanation about what might be deemed a reasonable failure to consent. So we have, basically what we've always said is, okay, buyer can request an assignment, seller shall not unreasonably withhold their consent with a time period that says, but, if you don't get the request in by our default, which is day 17, but could be negotiated to a different length. If you don't get your request in by day 17, then seller's consent shall be deemed reasonably withheld and seller doesn't have to agree to it. They could if they wanted, but they don't have to. That section has been expanded a little bit to still say that if buyer delivers the request after the deadline, that's a reasonable excuse for withholding consent. But it now also says that withholding consent shall be deemed reasonable if buyer's going to receive monetary or other compensation for the assignment, or buyer makes a misrepresentation to seller about any aspect of the assignment. So this, as you probably gather, is in a response to what's been happening with sellers feeling like they've been misled, buyers tying up their property, not being honest about their intentions, and then going out and trying to get money in their own pockets and have the seller close with somebody else. So just a couple new expansions on there, clarity about what everybody's options are if there is going to be an assignment. We get a lot of calls about this on our legal hotline, and they tend to come in waves. So I always get the sense that there's trainings out there, maybe telling people how you can make money in real estate with no money down by assigning contracts. And so we see these trends come and go, and they've been kind of prevalent recently.
Jan, excuse me for going back for a moment,
Sure,
just
yeah.
on the commission issues. There's a question whether there's a circumstance where a buyer representation agreement could obligate a buyer to pay compensation even if the deal doesn't close. And is that customarily negotiable?
So typically not. Typically on our buyer representation agreements, compensation is owed if an agreement is entered into during the representation period that then successfully closes escrow. The only time essentially where I think someone could or would pursue a compensation for a deal that didn't close would be in the event of a breach. If the reason the deal didn't close is because the buyer, breached that contract, then maybe theoretically the buyer's agent could say, well, that's also breaching my agreement and I've been damaged. I haven't heard of that happening. But short of that particular circumstance, the way our agreement set up, compensation is owed at the successful close of escrow. But I think either way could be negotiated if the parties wanted a different arrangement.
And then the buyer, if they want, can simply negotiate a fixed dollar amount for the compensation to the buyer's broker.
Absolutely, they can. Yep, they can negotiate a fixed amount or whatever amount they see fit. Absolutely.
Thank you.
Okay, so now changing gears a little bit, still kind of talking about the purchase agreement because this is an addendum to the purchase agreement. And for now, it is this FRRPA. It is attached right at the back of our residential purchase agreement. But I'll go ahead and tell you that as of June, the language in this addendum, or at least these concepts, are going to be folded into the purchase agreement directly. So if you're looking at our contract 6 months from now and you're like, where did that addendum go? It won't be there anymore, but this language or something substantially similar will just be folded into the purchase contract the next time we do an update probably otherwise minor, in our June forms release. But we update our forms in December and June, and sometimes laws go into effect in March, which is why we have the addendum for the time being. And so this is in response to these new FinCEN reporting requirements from the Treasury Department. And just to give a little background, for a long time, there have been what are called geographic targeting orders. So for properties in certain counties, not all, certain sort of more high value counties in the Bay Area, Los Angeles, things like that. If the buyer of the property was an entity and they were paying all cash and the purchase price was at least $300,000, then that buyer had to report certain information to the title company that they could then report to the Treasury Department. And it's an anti-money laundering law. It's basically, oh, these nameless entities are spending cash on houses and we think they're doing it to launder money. So for these sorts of transactions, we want to find out information about the people, the human beings behind these entities and crack down on money laundering. And that's been the case for a long time, but apparently it was decided that that was not going to be sufficient in terms of cracking down on this. So now we have greatly expanded reporting requirements above and beyond what we've had previously. So there's no longer a location limit and there's no longer a dollar amount limit. And who has to provide information has been expanded. So and then also on this form, I will say there's a brief history of how we got here. I can tell you this rule was passed last fall. It was supposed to go into effect in October. It got delayed. It was supposed to go into effect in December. It got delayed until March. And title companies and some other industry folks had really been fighting this because it is pretty burdensome on escrow and potentially title to gather this information and be responsible for reporting it. But none of those challenges were successful. And the rule did, in fact, go into effect as of March 1st. So anything that's closed since then that meets these requirements has been subject to these rules. And because it lays out what the requirements are in paragraph 2. So these reporting obligations apply if it's a residential 1 to 4 unit property or vacant land with the intention to construct residential 1 to 4 unit property. And the buyer is an entity or a trust. So it could be an LLC or corporation, but it also could be any kind of trust. There's no limit on revocable versus irrevocable, family trust or not. If the buyer is an entity or trust and the buyer is making what is considered an all cash purchase, which includes paying literal cash with no financing, but also includes hard money or private loans, or financing through a bank or institution that does not have its own independent money laundering reporting obligations. So that's pretty broad. That's basically any investor type transaction where they're paying cash or using a private loan. And it includes, like I said, not just entities, but trusts as well. And then the other really significant big expansion is that it's now not just buyers who have to provide information, it's sellers as well. So even though it's triggered based on the buyer's identity as an entity or trust, if they meet those other requirements, entity, trust, paying cash, then both the buyer and the seller have to provide certain information to escrow and title for reporting purposes. And this includes not just signers, also beneficial owners and beneficiaries. And this is where I've been getting feedback from escrow and title officers who I've spoken to about the implementation of this, where they're seeing the biggest sort of roadblocks because normally you're doing the transaction as long as all the signers are on board and working with you, that's fine. But now, because there's reporting requirements from beneficial owners who might not be signatories to the transaction, they're having to track down people to get information reported. And that information can be a lot. It says it's legal names, dates of birth, dates of execution of trusts, addresses, DBA, citizenship information for certain parties, tax ID numbers, social security numbers, account numbers. And a lot of this was already required to be included on a statement of information for buyers and sellers, but it is expanded and it does cover more people. So
Jana, is
yes.
generally being obtained using the title company's statement of information form, or is the escrow, are the escrows having their own forms for these things?
My understanding is that the escrows are having their own forms, that there's like a separate questionnaire. I have heard, and again, just sort of anecdotal reporting that there is also like there's additional charges being charged for this. So, it's an additional questionnaire. I've heard it's like 100-point questionnaire of information between all the parties, and that escrows are charging $100, $200, like there's a fee for FinCEN reporting paperwork. And I'm also hearing that it's taking more time, right? That I've heard some escrows say, you have one of these transactions, add a week to how long you think it's going to take to close. We need to factor that in. Be prepared to bring money in to close a transaction earlier so that we have more time to work with. So it's only been a couple of weeks. I will say I haven't heard any horror stories. I've talked to plenty of people that have successfully closed transactions. It's mostly just complaints about extra paperwork. Everyone already is not happy with the amount of paperwork involved in a transaction, and this is just I've heard like 5 to 9 more pages of paperwork involved. So that's been
reports of foreign buyers saying, I'm not doing this, and we're terminating the purchase.
not yet. So yeah, not yet, thankfully. And as far as it is sort of wrapped up into our contract, we have provision here that buyer and seller agree that, within 7 days, within 7 days of basically being informed that they need to provide this information, they will get everything to escrow to collaborate with the reporting, and letting them know that if someone refuses to cooperate, the transaction's just not going to close, and that whoever refused to cooperate, could be could be liable for breach of contract for failing to do so. I've had some people, some realtors, some lawyers tell me that, they might include a provision in the contract, basically creating a contingency for this, saying if they're unable to do it, excuse performance in the contract. Obviously, that's something someone could choose to include, but we have it just built in as, hey, this is a contractual obligation. If you are in this circumstance, you got to cooperate with escrow to close the deal. Otherwise, there could be problems.
We have a question whether there's anything similar to this for commercial or 5+ unit residential.
I wish I knew the answer to that off the top of my head. Someone asked me that yesterday, and really the question being, why is this just residential 1 to 4? It kind of logically leads me to believe that maybe there's some other requirement that is satisfying everybody's concerns for 5+ or commercial. But unfortunately, I'm just not sure off the top of my head. For whatever reason, this particular rule that went into effect this month is only residential 1 to 4.
Yeah, well, there are, I think, they suggested here reporting requirements for the banks, who are usually probably more involved in the commercial transactions. And obviously, this was their focus for money laundering, was the residential.
These residential cash purchases. Yeah. Like I said, if someone, and all of this goes away if anyone's getting a loan from a sort of conventional bank of any kind, then you don't have to worry about any of this because they're handling all of that on their end. So it really is only for these cash or private lending transactions. All right. So just a couple more things on transactional. Specifically, I wanted to highlight our unsolicited offer attestation. We were just talking briefly about issues relating to rebuilding and fire affected lots. And there was there have been all kinds of rules and emergency orders since the fires happened more than a year ago, regulating, prohibiting abusive practices, people coming in and trying to, take advantage and buy up damaged properties or vacant lots cheap and, limit that and cut out any predatory behavior. That was originally being done through executive orders and things, but as of October of last year, it is now California law that there is a prohibition on making unsolicited offers in certain zip codes, basically fire affected zip codes. We don't have the list of the zip codes. Oh, actually, I take it back. We do. It's in the title. So if you want to see what zip codes are affected, it's right up there at the top. And like I said, this has been in effect since October 10th. And so if for any transaction that is closing in one of these affected zip codes, this attestation, or one in a substantially similar format, has to be signed, and it has to be recorded with the deed at the time the transaction closes. And so what they're attesting to is that basically the property was listed for sale by the owner or their agent, and it was marketed on either the multiple listing service or a publicly available marketing platform. The owner had a for sale sign on the property or advertised it in a print publication or public place, or otherwise the owner publicly indicated their willingness to sell the property. Basically saying, we need you to attest, we need you to promise that this is not a circumstance where you, buyer, were just cold calling people who weren't otherwise interested in selling their properties to try to get them to sell to you. We want to know that this was a voluntary choice the seller made, and that they actually, were publicly marketing the property or otherwise going on the record with, yes, I'm offering my property for sale. Great, buyer, buy that property. But trying to weed out people making unsolicited offers. And so this has to be, like I said, recorded with the deed. It's quite possible that, I don't know if escrows and title companies have their own versions of this or anything like that, but we wanted to make sure it was available so that if somebody is closing an escrow in any of these zip codes, and I will say it's just in any of these zip codes. It's not, and there are parts of these zip codes that, could just be a house that was otherwise unaffected by the fires. Doesn't matter if you're closing an escrow in that zip code. Make sure that no one's making a unsolicited offer to begin with, and that the attestation is recorded when the transaction closes with the grant deed. All right. So couple agency notes before we, in the end of this program, talk more about landlord-tenant issues. But I want to talk about our listing agreement and our buyer representation agreement. Those, of course, have also been evolving a lot over the past couple years. I want to highlight this line item here in paragraph 2C of our residential listing agreement. This is new. If you follow residential real estate or the goings on with organized real estate, NAR, you might have seen some discussion about this at the end of last year. A lot of talk about referral fees, the payment of referral fees, and transparency relating to that. And so there's a lot of discussion about it. And this has been sort of discussed for a long time. There have always been rules in place, whether it's in the B&P code or the Realtor Code of Ethics or just fiduciary duty concepts, for people to be disclosing if they are receiving compensation of any kind, right? And that compensation could be for referring a client to somebody else. And so we have a form. I don't have a picture of it today, but we do have a form that can be used to make this disclosure, Realtor Acknowledgement and Disclosure Form. But what is sort of important to know here is that in the listing agreement and also in the buyer representation agreement, there is now a place, if the broker is paying a referral fee related to the representation of that client, they can disclose that and attach the disclosure that basically says as much. I am, paying a referral fee if I close a deal with you. And the disclosure also should be made by the person who is actually the one receiving that referral fee. And maybe they've already done that at the time the referral was made. I've talked to people who say, oh yeah, we've always done this. We get the client to initial on the referral fee agreement. If that's a practice people already have, that's fantastic as well. But we just wanted to make sure this wasn't getting missed by anybody. So now both in the listing agreement and in the buyer representation agreement, there is a place to indicate the payment of a referral fee and attach the document that's going to be used to make that disclosure, which can also be used as a standalone by the person receiving the referral fee as well. All right. And then one more note on the listing agreement, and this is another development based on another new law that went into effect on January 1st. You might have heard of this new law relating to the use of digitally altered images in advertising. And so this has been a hot topic in real estate for a long time, and fairly common for a long time, the concept of digital staging, showing what a vacant property would look like with furniture in it, or maybe taking the furniture out. But there are longstanding concerns about truth in advertising, avoiding misrepresentation. I'm sure Plenty of people have looked at a advertising for a property and then gone to see the property and feel like they're not looking at the same thing they saw in the photos online. And so now there are very specific rules about what has to be disclosed and what information has to be provided if the property is being advertised with what the law calls digitally altered images. And just to be clear, it doesn't include standard photo editing, brightness, sharpening. You take a photo on your smartphone and it kind of automatically brightens it up and looks nice. They're not worried about that. It really is digitally modifying the property, changing the paint color, putting in furniture, taking it out, changing the view outside the window, whether that's removing a utility pole or I heard an anecdote from someone where they did a sky replacement and put a beautiful sunset that you could see out the window, only for a prospective buyer to come to the property and realize that that window faced a direction that you would never see the sun set from that direction. So it's, photographers have a lot of tricks they get up to. Long story short, if you're going to have digital altered images in advertising, what the real estate licensee has to do is, one, disclose that the image has been digitally altered, either on or like in a caption immediately adjacent to the image, and then provide a way for the consumer to see the unaltered image. That could be a link, it could be a QR code, or they could just, depending on the type of advertising at play, right? If it's a flyer or something, you're probably going to have a QR code. If it's on the website or, certain MLSs, multiple listing services have certain rules, you just include the unaltered photo immediately preceding or following the altered one. And I've already started noticing this. I was scrolling through some listings on some publicly available websites earlier this week and started seeing an altered image with an unaltered image behind it. So that was good to know. But that's been sort of one of the hottest new laws that we've been talking to licensees about this year, is this use of digitally altered images. And so now we have a provision in the listing agreement that talks about it so that sellers understand what, why agent, why are you including, you fixed it up to look so nice. Why are you including the unedited version? Well, because the law says we have to. So it's in the listing agreement, so there's no confusion about that. All right. And then buyer representation agreements, buyer representation and broker compensation. Just a couple of updates here, but I wanted to highlight this one because this is, once again, tied to a legal development that went into effect on the first of the year. I mentioned before that we've kind of had this evolving regulation of buyer representation agreements, started with the settlement in 2024. Then January 1st, 2025, AB 2992 was passed, which was the California law mandating buyer representation agreements. And that law lined up in some ways with the requirements of the NAR settlement, but not others. In some ways, it was more expansive, or in some ways, it was more restrictive. And so, we've had kind of this year of, okay, there's certain settlement requirements, there's certain legal requirements. And then, like with any law that gets passed, people start finding the ambiguities, the points of confusion in it. And so what we finally got on January 1st was a new set of Department of Real Estate regulations applying to and interpreting that particular law. So the DRE came out and said, okay, here's what AB 2992 says. Here's what it actually means from our enforcement perspective. And one of the significant ones relates to a mandatory time period for buyer representation. The law said 3 months maximum, and a 3-month deadline seemed to be more confusing than I think anyone might have really expected. How do you count 3 months? And doesn't that make it uneven if you have February in the mix versus July? And so the DRE said that's not worth any confusion over. And they came out and said, well, 3 months means 90 days. So the maximum buyer representation agreement period is 90 days, no matter when it's entered into or what time of year. You'll see we have a note here in the representation period, sort of a bit of a safety clause, which says, okay, establish what your representation time period is, but the representation period shall end either on the ending date specified above or 90 days from the beginning date, whichever is sooner. So a little bit of a safety clause in there to say, no matter what you write in here, that legal maximum of 90 days is the maximum representation period. The DRE also clarified that yes, you can do a renewal for 90 days as well. That's been the biggest pushback I've gotten from practitioners over the past couple of years, which is just markets can be really hard. Buyers can't always find a property in 3 months or 90 days. And that's not surprising to me, especially in certain parts of the state. But renewals are okay. They're just also capped at 90 days, and they're capped at 90 days from the date the renewal is signed. So you can't enter into an agreement and then automatically extend it for 90 days. But if you get towards the end and the parties want to renew, they can do a 90-day renewal from the date that is signed. All right, and last thing on buyer representation periods, just a note there, you can see I also highlighted we have the same disclosure about payments of a referral fee on paragraph E4 there on the buyer side as we do on the listing side. And then we added some clarity to our paragraph relating to continuation periods. So this is the provision that says, okay, even after the transaction expires or if it is canceled, there may be a continued right to compensation for the broker for certain what are called broker involved properties. And this is to try to prevent any sort of practice of, okay, I'll get a broker to show me a bunch of properties and then I'll just immediately cancel or wait out the expiration and then, cut someone out of the deal and go buy the property. And it's optional. This time period does not have to be filled in. People can just say no when we're done, we're done. But if this is what they want to agree to, they can say for a set number of days, I'm entitled to continuing compensation if the buyer ends up purchasing one of those properties with broker involvement. And we just clarified what the triggering date is when that sort of continuation period begins, that it can be either at the end of the representation period when the contract expires, or if it's canceled, then it's from the effective date of the cancellation. I think logically that's always how it made sense, but this makes it crystal clear that that's what the rule is. So, and I will say, I get the question a lot, is there a maximum time period for continuation periods? It's not discussed in the law because this is a concept from our contract and not from AB 2992 or the regs or anything. But I do advise people to maybe keep it to 90 days to be consistent with the representation and renewal time limits.
Jana, I think reflecting some of the ongoing confusion we have about these buyer representation agreements, we have a couple of other inquiries. Someone asked you speak about the buyer broker agreement and the buyer needing to agree to pay the buyer's agent's commission even if the seller declines to do so. But I think, it just shows where people are not quite understanding the sequence and the
Absolutely.
agreements. And along with that is a question about when are the buyer representation agreements typically entered into. So maybe you can just sort of run through that sequence and how that works.
For sure. So yeah, this was sort of this sequencing has been the big change over the past 2 years when this concept was introduced. And so how it works now under the settlement rules and California law is that the buyer buyer's agents do need to enter into a buyer representation agreement with their clients, basically when they start working with them and prior to showing them any properties. And I will say that specific rule about prior to showing properties, that language is in the NAR settlement, but the California law says it needs to be entered into as soon as practicable. And the DRE regulations have now created a rebuttable presumption that as soon as practicable does mean prior to showing. So we kind of circled all the way around to that being the final answer, which is, prior to showing them a property, prior to driving out somewhere or even getting online and doing a virtual tour, the expectation and the requirement, frankly, is that yes, buyers and buyers agents will enter into a buyer representation agreement. And then, so the natural next question that somebody asked about how compensation works is that has to specify the compensation amount that the buyer's agent is going to earn. And it's a contract between the buyer and their agent. So yes, the buyer is agreeing, agent, I will compensate you X amount for representing me if we successfully close a transaction. And maybe they do, I'm going to tell you right now, that's probably not the most common way this plays out, but sure, the buyer could absolutely say, yeah, okay, I will pay you. This is a contract between me and you. We can negotiate whatever amount we see fit. and buyer's agreeing they're the one who's going to pay. But like we talked about at the very beginning in the purchase agreement, that's what that 3G3 section in the RPA is all about. That is a place where when the buyer writes the offer, the buyer can say, hey, seller, you know, I don't have, or, you know, for whatever reason, whether I don't have or I just don't want, doesn't really matter why. Seller, I'm asking you out of your proceeds to pay the compensation that's going to go to the buyer's agent. And that obviously is also totally negotiable. The seller can say, yes, absolutely. The seller can say, absolutely not. Or they can say, well, I don't want to pay that amount. I'll pay a lower amount. And if the seller says that they'll pay a lesser amount or they'll pay nothing, then contractually, the buyer does owe their broker that compensation if they end up proceeding with that transaction. It's negotiable, remains negotiable between them if the broker wants to reduce their compensation amount or make some other sort of arrangement. That's going to just depend on all the parties involved. But contractually, yeah, that's the idea. The buyer has agreed that they'll pay that amount, and then they can use the RPA to ask the seller and see what happens from there.
So how does that work, Jana, if the listing agent has a 5% commission and the buyer's representation agreement is a dollar amount that's less than half of that? Is the listing broker getting a windfall of more than half of the commission out of that? Or is the seller going to come back and say, wait, the commission should be reduced now? Or
yeah, so great question. That's one of the things that's changed, right? Is that when these new buyer representation rules went into effect, our listing agreements now specify that the compensation, and let me see if I have, right. So if you look at paragraph 2C1 there, the compensation for seller's broker, you'll see it says only seller's side of the transaction. So the idea is listing agent enters into a contract with their seller and says, okay, seller, you are going to pay me, just me. I'm not going to share it with anybody. It's not going elsewhere. You're agreeing to pay me X amount for representing you. And then the conversation they have with their client is, buyers are entering into an agreement to pay their agent. When they submit an offer, they might ask you to pay money to pay that agent at that time. But, the amount the seller's agreeing to in the listing agreement is exclusively how much they're paying their own agent for representing them. So there shouldn't be any windfall or anything like that. It's just, this is how much I'm earning. And then it's up to the seller how much, if anything, they're then willing to contribute to the buyer's agent's compensation.
And your section C2 here says that that listing agent, the seller's broker, is going to get more if they also represent the buyer.
Well, this section's a little bit tricky, and it's evolved a lot too. What C2 is saying is it is asking if the seller is willing to pay the agent extra money if they are dealing with an unrepresented buyer. So not for a dual agency, but truly an unrepresented buyer. And I can tell you, just policy-wise, this is in there and was put in there because there was a fear at the time when all of these rules went into effect that there may be a flood of unrepresented buyers. Buyers who saying, well, I'm not going to sign a buyer rep agreement. I think I can do this on my own. I'm going to come in here and do the transaction. And the concern being, okay, well, if they're going to do that, that's probably going to be a lot of extra work for the listing agent involved. And if they're not representing that buyer, they don't have a buyer rep agreement to get paid by them. They're just dealing with a lot of extra headaches. So they could, with their seller, agree, hey, if we find ourselves in this circumstance, I'll get additional compensation for all of the extra work that would go into that particular type of transaction. I have not got a lot of questions about this. I don't get the sense that it's happening really that often at all. I think most buyers still need and know they need assistance and are working with agents, but that's that's there for. Just if there is a truly unrepresented buyer, and if that might increase the listing agent's compensation.
And if there being a dual agent, does that come under one of these?
Then they would have, if they're a dual agent, they have their representation agreement with the buyer as well. And so, and it works contractually, it works the same way. Obviously, practically, the conversations could look different, but it's still.
But then they have a conflict with that clause where the buyer wants to ask the seller to pay their side of the commission, because now the broker's squarely in the middle of that negotiation on both sides.
Yeah, I mean, it's, dual agency is a very fraught, I think, set of circumstances. But yeah, they're going to have a representation agreement with each client, and then the seller can decide if they want to contribute to the compensation that's designated as being for the buyer's representation.
So we have a question about open houses and
Sure. Yeah.
representation agreements. And they're asking, what do you think about requiring people viewing a property at an open house to sign a buyer representation agreement?
So it's not necessary. I can tell you both from this is another thing that was in the NAR settlement and the new DRE regulations specifically clarify this as well. The DRE regs specifically say that if you are showing the property in the capacity as the seller's agent or the listing agent only, it could be in an open house. It could even just be as a showing. But if you are the listing agent and you are sort of making the property available in that capacity, that's not considered working with a buyer at that point in order to have a representation agreement to show them the property. You can just say, I'm here in my capacity as the seller's agent. Here's the house.
What if you, but what if you want to be signing up these people to be representing them on that or maybe other properties? Is it still acceptable, you think, to get that buyer representation agreement from somebody coming unrepresented to an open house?
So I would say that would be a conversation for sellers to have or listing agents to have with their sellers, right? Because maybe that's going to keep some people from not wanting to come in if this is a requirement of viewing the property. So you want to make sure the seller's on board with that. But that, obviously if they're already represented, your hands are probably tied. But if it's an unrepresented buyer, it would really be, I would say, need to be a conversation had with the seller of how do you want me to handle this? Are you comfortable with this policy? And making sure the seller is on board.
Very good. Thank you.
All right.
We're
I know we're once again at our last 10 minutes, and I want to make sure we can talk about these landlord tenant issues. I think we will be able to get it in just fine. So yeah, switching gears in our last 10 minutes or so here. There are, of course, once again, new tenant protection laws, new laws that landlords in California have to comply with, just like we see every year. And frankly, it feels like multiple times a year. The biggest and most significant one that everyone's dealing with right now is AB 628, which amended Civil Code 1941.1, which is the habitability requirements. So I think most people are familiar with certain habitability requirements. You need to have doors that lock. You need to have hot and cold running water. You need to have a heat, a working heat source, right? Well, now also that list includes a working stove and refrigerator. So the list of habitability characteristics now includes a stove that is maintained in good working order and capable of safely generating heat, and a refrigerator that is maintained in good working order and capable of safely storing food. And the reaction to this has been interesting. A lot of people were surprised that like stoves weren't already required, but they weren't. There was no requirement to have a stove until now. But the bigger sort of hurdle for people to clear is the refrigerator issue, because it's really common. I think actually more in the greater Los Angeles area. People in other parts of the states are like, oh, I've never seen a rental without a fridge. So this can vary a lot, but it's kind of common from what I've heard, and frankly, in my own historical experience, for rentals in Los Angeles to not have a refrigerator. And tenant, that's just on you. And that is no longer going to be allowed. Now a refrigerator has to at least be offered to be provided, and we'll look at what the technical rules are. Just to get ahead of a few different questions, the kind of questions I've been getting is there a minimum size the refrigerator has to be? No, we're literally looking at the text of what the requirement is. But I always tell people, don't get cute with habitability requirements. I wouldn't want to be standing in front of a judge defending the little dorm-sized mini fridge that I put in my rental property as a refrigerator. It doesn't have to be brand new. It just has to be maintained in good working order. Does it have to have a freezer? The law doesn't say. Capable of safely storing food. I think you could craft an argument that might include an ability to freeze things. So that might be sort of a conservative approach to say, yeah, it should have a freezer, but does it have to have an ice maker or filtered water or anything like that? No, just a refrigerator that works, that can safely store food. Now, this is a habitability requirement that in a certain way is kind of waivable, unlike most habitability requirements. The tenant, because maybe they have their own fridge and they say, I don't want yours. I want to bring my own fridge. Well, they can choose to supply their own refrigerator if, as long as the lease contains a required notice about their rights. Also, though, the lease has to allow them to change their mind. So they can say, I'm bringing my own fridge, but at any point, let's say their fridge breaks and they don't want to buy a new one, they can give a 30-day notice to the landlord. And now the landlord does have to provide a refrigerator. And this is not something that the landlord can't make this mandatory. They can't say, I'm only going to rent to you if you sign, agree that you're bringing your own fridge. It has to be voluntarily entered into. And this new rule applies to leases that were entered into, extended, or amended after January 1st. So if someone's been in a fixed term lease since before then, nothing has to change. But if that lease is going to be, signed and extended for another year, then this all needs to be dealt with. And for existing month-to-month tenancies, it's not 100% clear, but what the sort of most logical interpretation of the law seems to be is as soon as you amend that, so if you're going to do a rent increase or anything that's going to modify the terms of a month-to-month tenancy, that is when this requirement is going to kick in. So, of course, we have updated our forms to address these issues. We also do note there are some exceptions to this requirement. So permanent supportive housing, single room occupancy, residential hotel, something with communal kitchen space. It also doesn't apply to true vacation short-term rentals of 29 days or fewer. Otherwise, rental agreements need to have the notice, the language that's included in 11B there, letting them know that the law requires the landlord to provide them a refrigerator that's kept in working order and stove. But if they have, they're being asked to acknowledge if they want to bring their own refrigerator. That is something they are doing by choice. And there is a checkbox there for them to indicate that. But again, of course, they can change their mind at any point on 30 days notice. So this is in our standard residential lease and month-to-month agreement, and it's also in our extension of lease and our change in terms of tenancy forms as well.
Does this stove and refrigerator requirement apply to guest units within a multifamily building?
like an ADU, for example? It seems to. If they have their own if they have their own kitchen space of any kind, then if it's not like a single room occupancy, right? So it's not like you're renting out a room. If you're renting out a room, that's fine. But if it's an ADU, then the tenants are residing in it, then yeah, it seems like that is going to apply in that circumstance.
What is the remedy if the landlord refuses to provide the refrigerator?
So it is, because this is a list included on the list of habitability requirements, it's the same potential remedies for any non-habitability claims, theoretically. So, withholding rent, defense to an unlawful detainer action, buy it themselves and then deduct it from the rent, theoretically. So yeah, it would be considered a non-habitability claim, just like if the landlord didn't fix a broken heater or something like that.
And if the tenant had already bought the refrigerator before this law came into effect, they can just leave it there, or I guess they could take it out and ask for a refrigerator.
Yeah, that's correct. All right, so with our last minute, I just had one more landlord-tenant law I wanted to mention, which is yet another new rule for the handling of security deposits. We've also seen the security deposit law change so much over the past couple of years. This year's change is that now there is a new rule that if the security deposit was paid electronically, then by default, the landlord has to return that deposit electronically. Previously, they could just send a check, but if the deposit was paid electronically, the landlord has to return it electronically, also presuming that there was only one tenant. If there are multiple tenants, then the default is still, okay, it's going to be returned via check in all of the tenants' names, unless the tenants elect otherwise in writing, which they have to be given the opportunity to do. Also, the default is still that the itemized list of deductions is going to be provided by mail but they can elect to have that sent electronically as well. And this all needs to happen at the termination of the tenancy. So in our notice of right to pre-move out inspection, as well as our pre-move out inspection form itself, we have the required notice letting the tenant know about this rule, and that their deposit will be electronically if returned if the conditions are met. And then also giving them the opportunity to request that their itemized statement be sent via email, or even if they didn't pay the deposit electronically, or there's multiple tenants or something along those lines, they can opt in and provide information to have the deposit returned electronically as well.
Two more questions. Someone has asked if you could provide information for attorneys to get access to the C.A.R forms. My understanding is that you might get exemplars, but the forms you have to sign up with C.A.R, right?
Yes. And my understanding is that it is possible for attorneys to purchase access. I don't know what the current rules are as well. But if someone wants to send me an email, I can connect them to the best person at C.A.R that handles those sorts of things. So, Jana G, JANAG at CAR.org. If they want to get in touch with me, I can put them in touch with the people that handle all that stuff.
And if you didn't get that, you can always send a request to me. I'll forward it on. Another question: are you aware of a situation where when a buyer refuses to pay the buyer's broker, and the buyer's broker steers the buyer to properties where a commission will be paid? I guess assuming they're saying it'll be paid by the seller, but.
Right. I know. I'm going to be very honest with you. No, I have not heard about that. The whole point of all of these rules and everything is so that exact thing doesn't happen, and that, compensation is completely negotiable between clients and their own agents, and then principal to principal, buyer and seller, with each offer that is submitted. And so that is what is happening out there.
There's nothing new on background checks of tenants, is there?
Not this year, not recently, no. I know there've been additional rules over those the past few years in terms of if you do a background check and having to basically, tell them what the results of it were and how they can see their own information and all of that, but nothing's changed in the past couple of years.
So I want to thank everyone for attending. We had a very big group here today, and a huge thank you to Jana. You're always fantastic and on top of everything. And we had a lot of questions today, and all of them got answered. So thank you so much. And we're so happy that you joined us again this year. Thank you.
Yeah, you're so welcome. It's always great to be here. Thanks for having me.